Hi folks, and welcome back to Contract Law. This is the very last, absolute promise, very last video on the consideration series, and we are just stepping through the 6 elements of promissory estoppel, equitable estoppel. In the first video, we had a look at the difference between common law estoppel and equitable estoppel, and we traced its development from the old railway cases in the 19th century through to Walton Stores and Marr, and we finished off with the 6 elements from Justice Brennan's decision in Walton Stores and Marr. So what we're going to do in this video is just step through each of those 6 elements. The first element is that there's an assumption or expectation that's adopted by one of the parties, and here you need to be very careful to identify exactly what the expectation is. It might be an assumption of fact, it might be an assumption of law, it might be mixed, but in any event, that assumption, according to Brennan, will have 2 limbs to it. Firstly, the assumption itself, and secondly, the more, implicit assumption that the other party won't be able to renege or resile from the assumption that has been adopted by the other party. Okay. In a subsequent case that we'll look at in just a minute, Priestley tinkered around with this first element a bit and broadened it out, saying that it will suffice if there's an assumption that a contract will come into existence or a promise will be performed or an interest granted. In that case, there was an interest in a lease. Priestley's formulation of the first element drops away that second limb that's implicit in Brennan's decision. I guess that's just a little bit of legal nitpicking that goes on, really, but the gist of the first element is that there has to be some kind of assumption. Now, that will normally be induced by some kind of representation, and the representation that induces the assumption or expectation has to be very, very clear and unambiguous. Why is that? And the courts have been very strict on this. It's because equity is directed at relieving against unconscionable conduct, and a court's not going to actually step in under the guise of equity and interfere with something as serious as enforcing a promise unless it's absolutely clear to everyone in an objective sense what that representation meant and how it would have been understood. Bear in mind that you're about to enforce a promise that has had no support of consideration. Some of the journey made me where the dear little secretary said, I think that should be all right, but I'll have to get instructions. Not clear and unambiguous enough for the court there. In Crown Melbourne and the Cosmopolitan Hotel case, a more recent High Court case, 2016, the phrase "will look after you" at renewal time, again another leasing case, will look after you, not clear. So the argument of promissory estoppel failed. So first element has to be an assumption or expectation, and the representation made by the other party has to be quite clear in order to found that assumption or expectation. In Estoppel and Franklin's, this is the decision I was referring to previously. Franklin's was a large supermarket chain. I'm not sure if they're still going, but this was another leasing case. Franklin's had worked on their specifications that they wanted for a new store that they were going to lease from Estoppel. They spent money on the fit out and getting themselves to the point where they could actually finalise the lease arrangement. Franklin's were fairly confident about this deal. In fact, they'd already terminated their existing lease, so they thought that this was home and hosed. They negotiated for a large amount of extra space, but what they didn't do was agree on a price for the extra space. Franklin's kind of thought that they might be able to slip one by on Estoppel. So they kept negotiating. Estoppel needed to secure some finance, and the financier requested a commitment from Franklin's, obviously, because Austertel is going to be much more able to bankroll the building process if they had a major tenant like Franklin's on board. Franklin's wouldn't actually commit for Austertel to secure their finance, and so Austertel got fed up with Franklin's and spat the dummy and started to negotiate with Bilo. Again, I'm not sure if Bilo is still going, but another grocery supermarket chain. Franklin's then stepped in and sued. I mean, they'd already spent money on getting themselves to the point where they were fairly confident with this leasing deal. They sued to stop Austertel from resiling from the lease that Franklin said it had assumed would eventuate. Priestley, as I said, expanded Brennan's notion of a qualifying assumption or expectation, dropping that extra rider that the plaintiff has to think that the defendant couldn't resolve. They have to turn their mind to the fact that they think the other party can't renege on whatever it is that they've represented. And here we see the constraints being applied to keep this doctrine within manageable limits, because otherwise it's really going to undercut the whole issue of the doctrine of consideration. It was held that Franklin's had deliberately failed to mention this additional rent for the extra floor space, and it just hoped that the topic wouldn't come up. As I said, they were trying to slide something by on Austertel here. Franklin's then couldn't rely on an assumption that a lease would be granted before the additional rent was agreed. It had made this deliberate gamble, and unfortunately for them, they didn't win on that occasion. So Kirby and Rogers held that for a court to go ahead and actually write in for the parties what the lease should have been was a very, very serious affair, and it would constitute a full frontal assault on what is generally required to make an agreement. What they were saying was, if you let something like this go by as an example of promissory estoppel, you really would have the whole doctrine of consideration in tatters. Kirby said that courts shouldn't substitute lawyerly conscience for the hard-headed decisions of business people. Both Austertel and Franklin's had legal advice, and Franklin's had made a commercial decision to, as I said, roll the dice and try and slip this through on Austertel. It failed. They couldn't then turn around and argue estoppel. So that's element one. Element two is inducement. And this is really the link into equity and unconscionable conduct. So the defendant themselves has to actually play a part in the plaintiff adopting that false assumption. And generally speaking, you're going to have a representation. It can be by words, by conduct. It can even be by silence. But it has to be, as you can see in the other little planet over here, it has to be an inducement by the defendant. So the plaintiff's wrong assumption has to be caused by the defendant and their representation. You can't actually set up someone for a case of promissory estoppel. That's what happened in SkyWest and the Commonwealth. That case was one of a string of cases that was involved in the Commonwealth trying to source a contractor to do some aerial surveillance work at the top end of Australia. And they'd come to grief with an earlier contract with A-Man Aviation, and we'll look at that case in a later video series. And then once that contract had been terminated, they then started negotiations with SkyWest. Now, SkyWest came in so low in their tender that they were actually going to be charging less than what it was going to cost them to do the job. Part of the reason was because it would cost SkyWest so much money to refit the planes to do the aerial surveillance work. And so what they started to do, these members of SkyWest that were conducting the negotiations with the Commonwealth, is they started to drop in a term that they call equalisation. They started every now and again in their conversations, they'd drop the term equalisation. Of course, the Commonwealth representatives of the negotiation had no idea what equalisation meant, and no one asked. And then eventually, when it came to working out how much SkyWest were going to be paid, They made an argument that the Commonwealth should be stopped from equalising or paying for the cost of the refit out of the planes. And the court said, as you can imagine, the court said no. Unfortunately for SkyWest, if there's going to be any argument of estoppel, it has to, the representation and the inducement to adopt an erroneous assumption has to be has to be issued from the defendant in the case. So that was SkyWest. As I said, we'll do AMAN Aviation later. Equally delicious factual circumstances in that one as well. The third element is reliance, and reliance has to be reasonable in all the circumstances. So not only does the party have to be induced to make this wrong assumption, but they have to actually act on it, and they have to rely on it. This element has thrown up a couple of interesting questions. Firstly, what happens where parties are negotiating subject to contract? Subject to contract, as we saw in Masters and Cameron, usually means that one party is signalling that they don't believe that an actual agreement has come on foot yet, and it may never come on foot unless and until it's been reduced to writing and signed by the parties. So what about in that kind of situation? If one of the parties expressly says, look, this is all subject to contract, what does that mean? Does that mean that then what is said in those negotiations really can't be the subject of an estoppel, because it's very clear between the parties that no legally binding agreement is intended to come into play yet? Brennan's view, as you can tell, because it's got that second limb there, that the party that's making the assumption has to actually turn their mind to the fact that they think that the other party can't legally get out of whatever it is that they've represented. And therefore, the notion of estoppel would probably be knocked out by something like one of the parties saying, look, this is all subject to contract. The broader view and the less harsh view, I guess, is that equity should be able to step in and provide a remedy wherever there's inequity. The consensus there tends to be that Brennan's view would probably prevail, but I'll leave you to ponder on that one. A similar question arises as to whether merger clauses might prevent the doctrine of estoppel from applying, and that is where you have a specific clause in a contract that says this contract and the terms herein are the entire agreement between the parties, and neither party is relying on any earlier or other representations. This is it. This is all of the terms between us. Would something like that knock out the doctrine of estoppel? Gore's view on this is that it probably wouldn't knock out estoppel. It might create problems, evidentiary problems, because it's going to be pretty hard to show that, notwithstanding a clause like that, you still actually went ahead and relied on this erroneous assumption. But technically, the argument would still be available. It might just be more difficult to make. So that's element 3, reliance. Element 4 is knowledge or intent. And this element is really what ties the whole unfortunate situation that the plaintiff finds themselves in to the defendant's conduct. This is where you really very clearly see the inequity happening. The party inducing the adoption of the assumption must know or intend that the other party is going to act on it or abstain from acting. So they don't do something. They either do something or they don't do something they wouldn't otherwise have done, but for this erroneous assumption that they've got. So it's kind of like seeing someone heading for a cliff edge, and you know they're going to fall off and just saying nothing. Kind of similar situation here. The knowledge might be constructive, that is, a reasonable person in their situation would have known, so therefore this particular defendant ought to have known that the other party was going to act on this erroneous assumption. and it's broad enough to sweep in notions of willful blindness. So if you can see someone heading towards that cliff and you say, what a nice day it is today, look up at the sky, what a blue sky this is, you're willfully blind to what's about to happen, then in that circumstance you're going to still be held to have the requisite knowledge or intent. The fifth element is detriment, and this one's not too hard to wrap your mind around, really, is it? The plaintiff's going to have to demonstrate some kind of loss, so changing their position in reliance on the assumption and then suffering some kind of material disadvantage if the defendant changes their mind and resolves from this assumption that they've induced. Element 6, again, no real problems with this one. It's just the conclusion, I guess, the concluding act to the whole sorry story. So the defendant has to have failed to step in and avoid detriment for the plaintiff. So they haven't fulfilled the assumption or something of that nature. So essentially they've seen the other party heading for the cliff. They knew that they were going to head for that cliff. They intended for them to take that pathway to the cliff, and they didn't actually stop them from falling off the cliff. So that is element 6. Like I said, no real problems with that one. And then we just have to talk quickly about remedies. Now, one of the issues that has cropped up in the doctrine of promissory estoppel is should the defendant be held to make good that assumption each and every time? Is that actually what should be going on? Because there is a maxim that says equitable relief should be the minimum equity required to do justice between the parties. So not necessarily in every case should that defendant be forced to make good the assumption that has been wrongfully adopted by the other party. And this is certainly what was held in Commonwealth and Reliance, a very unfortunate case of personal injury by a service person in the Navy that was injured when two ships collided. In that case, the Commonwealth had said that it wasn't going to rely on certain causes of action, and in fact it changed its mind and did argue those causes of action. The question for the court there was, should the Commonwealth be held to its representation, or should the court just give the minimum equity involved? And in that case, the plaintiff just got minimum equity involved, which was the costs incurred in the litigation from the time the Commonwealth said it wasn't going to rely on those defences up to the point where it changed its policy. Very unfortunate case, really. There was some discussion of stress and all sorts of things going on in this poor survivor of this tragedy. Dean and Dawson in that case had a different view, but they were in the minority, so their view wasn't actually part of the ratio of the case. But they said, what you should be doing here, yes, there's this maxim that, you know, equity should only give the minimum equity to right the wrong. They said what you should have is a default position. The default position should be there's a prima facie entitlement to preventing departure from the assumption. The defendant shouldn't be allowed to go back on their word. But if that's going to cause injustice or some other real significant problem, then, you know what, a lesser relief can be made available. That's probably a more even-handed approach to things, and it certainly would have been better for the plaintiff in that case. The High Court had a chance to revisit that issue in Gemelli and Gemelli, and they actually followed the dissentients in Commonwealth and Reliance. So they said the correct approach is to make good the assumption unless that's going to exceed what could be justified by the requirements of good conscience and be inequitably harsh on the defendant. So in that case, we had, it was a family dispute over land. The land was not conveyed to the plaintiff, which is what they wanted, but they got the value of the land instead secured by a charge. So at least we have a bit of common sense prevailing, maybe not common sense, but I guess good conscience prevailing in the default position now as to remedies. And that is the notion of estoppel. And that is the end of our video series on consideration. Like I always say, guys, if you have any queries or questions, please don't be afraid. Reach out, email me, tweet me, whatever you like. Contact me on Teams, and I'm only too happy to chat with you. Hopefully I get to see you in a tutorial sometime soon. Other than that, thanks for watching. Bye, guys.